Welcome to Chapter 4 of Law in Australian Society, which is all about the founding principles that underlie our legal and political system. In this chapter you'll learn about 5 key concepts that underlie our legal system, starting with liberalism, then democracy, federalism, separation of powers, and the rule of law. Liberalism is a political philosophy that emphasises individual freedom from government interference. So this includes civil liberties like the rights to privacy, freedom of speech, and private property. Liberalism has its roots in 17th century English and French philosophy during a historical period known as the Enlightenment. So key figures in liberal philosophy include John Locke, John Stuart Mill, and Jean-Jacques Rousseau. The harm principle is a core aspect of liberalism. It says that government should not interfere with our lives unless we seek to harm others. And this is a core underlying idea of the criminal justice system, being that criminal offences prevent us or prohibit us from doing certain things, but otherwise we are free to do as we wish. And freedom is that core idea underlying liberalism. We should all be free to do as we would like, provided we're not doing anything to harm other people. Democracy is a political system where governments are elected by the people. This seems very obvious in Australia, where we have elections every 3 years to re-elect our national government and also our state governments. But there are very different types of governments, like authoritarian governments. Democracy has its roots in Greece around the 5th century BC, and it's captured in the famous words of Abraham Lincoln in the Gettysburg Address, where he said that democracy is government of the people, by the people, and for the people. And this means that we elect our members of government, and that they should also act in our best interest. Parliament is a representative forum where you can see democracy in action. So Parliament has members that we've elected to sit in Parliament, which we talked about in the previous chapter, and it's also where they enact laws on our behalf, and that's the key idea of representative government. Federalism refers to a system of government which has both a central government and several regional or state governments. So in Australia we have the federal parliament in Canberra, and we have several state governments, 6 state governments and 2 territory governments as well. So it's about a system that has central lawmaking power and devolved or regional power out in other areas. In Australia, Section 51 of the Constitution grants the Commonwealth specific lawmaking powers. The list is quite long, but the idea is that the powers of the Commonwealth Parliament are meant to be limited compared to those of the states. So the states have plenary power, meaning the power to enact laws on any topic. But in practice, we've seen the Commonwealth gradually acquiring control over lots of areas that are traditionally within state responsibility. So if you think about the national curriculum, for example, education is traditionally a state responsibility, but the Commonwealth has taken greater control over this area over time. This is called centralisation because there's becoming more central power within the country in the national government. This can cause lots of disagreements between the central national government and those of the states. For example, there's often debates about the hospital system, a lack of hospital beds and funding. For the Commonwealth government, they see this as a failure of the state governments to look after hospitals adequately. For the state governments, they see it as a failure of the Commonwealth government to give them enough money to do so. The separation of powers is a core idea underlying liberal democracies. So this is the idea that government should be divided into 3 arms. We start with the legislature, and this is just a fancy word for parliament because it makes the laws. Then there's the executive branch of government, which we talked about in the last chapter, which administers or uses the laws in practice, and then the judiciary, another name for the courts. This idea of dividing power between 3 arms of governments is usually attributed to Baron de Montesquieu, a French political philosopher and judge. And the idea is that power should not be concentrated in too few hands. If you had a system where politicians decided what criminal offences were and then punished people under them, well, then there would be too much power with those politicians to rule the country. So it's all about dividing power between different arms of government. However, in Australia, there's not a strict separation of powers because, as we've talked about, ministers, who are part of the executive, also sit in Parliament, so they're also part of the legislature. This is designed, though, to enhance responsible government, and the idea is that ministers, by sitting in Parliament, are more accountable to the people. And the final of these concepts that we talk about in the chapter is the rule of law. So the rule of law is a difficult concept to tie down to a single definition. It's really an ideal that all countries should aim to achieve in their legal system. Having the rule of law means that laws are clear and publicly accessible. So we've talked about accessing laws through OSLI or government websites. It also means that people are treated equally under the law. So if you're the Prime Minister or a billionaire business person or just an ordinary citizen, well then the laws still apply equally to everyone. And it also means that government should be free from corruption. And it entails some minimal degree of protection for individual rights like justice and equality. It doesn't extend normally to human rights, which we talk about in a later chapter. And this isn't just an ideal, it does have legal force. So in Australia, in the Australian Communist Party and Commonwealth, 1951, 83 CLR 1, that's the citation, but it's commonly called the Communist Party case, Justice Dixon held that the rule of law forms an assumption of the Australian Constitution. And we do have strong protection for the rule of law in Australia. So in 2018, Australia is ranked 10th in the world on the World Justice Project's Rule of Law Index. So to reiterate the key points from this chapter, Australia is a liberal democracy. This means we have a democratic system of government that is founded on the principles of liberalism. Australia also has a federal system of government. We have a national government in Canberra and 6 state governments. Separation of powers is another important principle, which says that power should be divided between 3 arms of government: the legislature, or parliament, the executive, and judiciary, which are the courts. And the rule of law means that laws should be clear and accessible and that everyone is treated equally under the law. Some discussion questions for your lectures and tutorials. So what's the difference between liberalism and democracy? We often group these concepts together by saying a liberal democracy, but if you start teasing them apart, do the concepts have differences or similarities? What is a federal system of government? What are some advantages of federalism, and what have been some of the challenges with having a federal system of government in practice? What are the 3 branches of government, and why do we separate power between them? How are legislative and executive powers blurred in Australia? Why is this done? What is the difference between representative and responsible government? These 2 concepts are often confused by students, but they mean slightly different things. What's the difference between the formal and the substantive requirements of the rule of law? What kind of protection for individual rights does the rule of law provide? Which countries do you think provide the best examples of upholding the rule of law, and which provide the worst? Why do you think that these countries are either the best or worst examples of the rule of law? And if Australia ranks 10th on the World Justice Project's Rule of Law Index, what are the countries 1 to 9? And why do you think they rank higher than Australia?